Possibly one of the biggest mistakes anybody or any company could make is getting into an agreement without reducing it to writing. This is a problem we see time and time and time again with individuals, with companies, believe it or not, even with solicitors and with barristers. Barristers particularly must get everything in writing, and they cannot act unless they've agreed to instructions in writing, whether that's instructions from a solicitor or instructions from the general public as a public access practitioner, such as myself. So across the board, this is simply one of the biggest mistakes we see people make on a regular basis. Think of the scenario in this way. Let's say you want to pay to have some work done on your house. It's going to cost you about £3,000. If you were to go to a cash machine or to go to a bank and withdraw the cash so that you have a pile of money sitting on your table right now, you're looking at £3,000 on the table, and this is the money that you are planning to give to somebody for the work that's going to be carried out on your property. Let's say now that somebody turns up at your property, the person or a representative of the company that's supposedly going to do this work on your property. You take this cash and physically hand it to the person and let them walk away. Does that sound like a very good idea to you? Obviously not, because the person walking away with the cash has given you no receipt. They've given you no confirmation in writing as to what they're going to do with the money, when they're going to do that work, to what standard, or who's going to do it, who's going to pay for the materials, who's going to pay for the tools, when is the work going to be done, is it this week, next month, next year? Who knows? Because if you don't get anything in writing, this is essentially what you are doing with the cash. You are handing someone the money with whom you have failed to reduce to writing any of the agreement for work on the property or whatever it is the work that you want carried out. Now, this is obviously much worse if you've quite literally handed cash to this person, because unless they give you a written receipt, and even then there might be problems with the receipt, but if you've given somebody cash, it can be far more difficult to prove that you have in fact given this person the money. Imagine a scenario a year and a half down the line after the dispute when you are in court and you want the judge to believe that you handed this money to the person and they gave you no receipt, no confirmation, no written confirmation, there was no written agreement between you, there's no written contract between you, nothing has been reduced to writing, there's no bank account that you can point to where you sent the money because you physically handed the person cash. How, in that scenario, do you expect the judge to believe and side with you with the fact that you've handed this money to the other person? If, as they are going to listen to the other party, flat out denies that they received this money and that you are making it up. So in that situation, the judge can only hear evidence from both parties, and if there is nothing in writing, essentially it's your word against theirs. And the judge is going to have to make a determination of fact based on the evidence that the judge hears. But in some situations, the judge is simply going to be unable to make a determination that orders a party to hand over money when there's simply not enough evidence. Now, this might be for the whole of the agreement between you, or it might be for part of the agreement between you. Let's say that you've paid £15,000 through bank transfers, but you say that you've paid an additional £4,000, for argument's sake, in cash payments on an ad hoc basis here and there, but you've got no receipts, you've got no written confirmation, and it's your word against theirs. Again, put yourself in the judge's shoes. How is the judge going to make a determination that you did in fact hand this money over when it's just your word that you did and their word that you didn't? So very often when you go to large companies and you get lots of terms and conditions and lots of people complain about the amount of terms and conditions and not wanting to read them, they are actually protecting both parties in the equation. Because very often, if the terms are wholly unfair, particularly if you're a consumer, because the laws are tighter for consumers and unfair terms in consumer contracts, more on that in another video, but these terms and conditions will govern the agreement between you, and if something is unfair, then it may deem to be unenforceable anyway. But at the very least, there is a written agreement, a contractual agreement between you setting out what the terms of that agreement are. And in the event that you don't like one of these terms within the contract, you can simply cross it out, indicating that you don't agree to that term in the contract. Moreover, if you agree something in addition to that contract, first of all, check that there isn't an entire agreement clause in there, in which case nothing said outside of the agreement would be part of the contract. But in any case, you could cross that out, so it's not part of the agreement. Or what you can do is write onto the agreement and get the other party to initial to say that they agree an additional term that you are putting in the contract because that's what you want in the contract. Companies and individuals are free to do this. Generally speaking, parties are free to contract with each other for whatever they want, providing it's a legal contract. Obvious example, a party cannot sue another party for non-payment for illicit drugs when the contract was illegal in the first place. I hope that was as obvious as it sounds. But for some reason, when it comes to work on a property or work on the garden or landscaping or lending another business money, lots of people enter these agreements, and I use the term loosely because the agreement isn't reduced to writing, so nobody can point to what the agreement is. But nonetheless, there is some form of an agreement between the parties that eventually, if one of them moves away from these terms, they're going to want the court to decide what these terms were. So if there's one thing you take away from my channel and the hundreds of videos that I've put up on YouTube, it is, please, I implore you, do not hand over any money, whether it's a bank transfer or much worse, in physical cash, unless you've reduced this agreement to writing. Because unless you've done that, it's going to be very difficult later to convince somebody that that was the agreement. The only time that can work is if there was an agreement that you've lent somebody money and it goes into their bank account and you can see, let's say it's £3,000, and they were to repay you that money at £100 a month, and you can see that for 18 months, £100 regularly has been coming into your bank account from that person. Then perhaps the judge can come to the conclusion that they were paying you back that money and they were going to pay you back. However, the scenario might crop up where the other party says, no, it was only half of it that I agreed to pay back, and the other half was for something else that was also not in writing. This, again, makes it much more difficult for a judge to come to a determination of fact as to what the agreement was, and ultimately, as you would want them to, order this other party to pay you the remainder of the money. So if you want to see more common mistakes that we see all the time and how to avoid them, I suggest you watch this video here.